Judge Torres winks verdict in SEC case against XRP Ripple. Is it possible to relist XRP on Coinbase? What will such an event lead to? We will answer these questions in today's video. The current price of XRP for today is $0.35 and the trading volume for 24 hours is $136,000,000 We are updating our XRP price in US dollars in real time. XRP has dropped 30% in the last 24 hours. Welcome to the Rich Club channel. If you like this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end to like and subscribe. The Relative Strength Index, RSI, has not been definitive over the past few days. Last week, the RSI held a neutral value of 50 as support, but recently this level has not passed. Thus, there may be some volatile dynamics during the weekend. Similarly, the Awesome Oscillator, AO, was also below zero. He has not yet shown a strong bearish impulse. The A/D line had a resistance zone that was directly overhead and was indicated by two dotted white lines. If A/D can overcome this region, it will be a sign of sustained demand for the XRP rally. The Directional Movement Index, DMI, showed the absence of a strong trend. ADX, yellow, it was at level 20, ADI just above the 20 mark. Technically, this indicated a bearish trend, but in general meant the absence of a significant trend over the past few days. The $0.35-$0.36 range will be important to protect the bulls over the next day or two. The formation of a lower low below this area will signal bearish strength. Momentum indicators were inconclusive on the lower timeframes. Bitcoin could also strongly influence the direction of XRP in the near future. A big victory for XRP holders was the decision of Judge Analisa Torres, who rejected a request from the U.S. Securities and Exchange Commission, SEC, to revoke Amici status from future proceedings. Lawyer James Phelan, who shared this important event on Twitter, mentioned that now John Deaton, who advocated for XRP holders, can stay in the case. He added that Amici cannot participate in the expert competition yet. However, he may apply for a brief discussion with an expert of the commission in a simplified trial. According to the court's ruling, on October 4, 2021, Movin was allowed to act as an amici curiae. It also gave them permission to hold a briefing on legal issues relevant to the case. He stressed that such assistance could be useful during a briefing on judicial petitions. Reacting to this development of the case, Deaton said that the XRP community should value and respect the two judges. He added that Judge Netburn's decisions were neutral and fair for both parties at the discovery stage. However, Judge Torres' conclusions are correct. Meanwhile, she technically denied his immediate move. John Deaton said that the commissions did not object to token holders in Auckland for having an expert opinion. This happened because their XRP holders sued Ripple. Deaton mentioned that he identified 5 such holders in this lawsuit. Meanwhile, here in this lawsuit, he has about 69,000 XRP holders. The Securities and Exchange Commission says they can't get him and tried to remove him from the case. The Securities and Exchange Commission, SEC, has filed an objection to Judge Sarah Netburn's recent decision ordering the agency to hand over internal documents to Ripple for William Hinman's speech in 2018. According to the SEC, the internal drafts contain confidential SEC information and are unrelated to Ripple's statements. The court has already ruled 3 times that the SEC must disclose these drafts to Ripple, but the agency continues to insist on its own. Even if they were relevant, the drafts of the speech contained confidential discussions and legal advice protected by the privilege of the deliberative process, DPP, and attorney-client confidentiality, the SEC said. According to the SEC, if the court retains its decision to transfer Hinman's documents to Ripple, certain consequences may arise that could freeze internal communication not only at the SEC, but also at other agencies. Hinman's denial of responsibility for the fact that the speech contained his personal views was a central element of Judge Netburn's decision, as she believes that the communication that led to the preparation of the speech was not an agency discussion. The SEC stated that the disclaimer Hinman used before the speech is a standard procedure to ensure that market participants will not view the comments of SEC employees as commission policy. Indeed, Director Hinman consulted with dozens of SEC lawyers for many weeks, some of whom reviewed and edited several versions of the speech, the Securities and Exchange Commission said, adding, "If the orders remain in force, they will deprive civil servants of the opportunity to discuss important policy issues and receive sincere legal advice from the agency's lawyers. The orders should be cancelled as clearly erroneous and contrary to the law, and the Securities and Exchange Commission should be allowed to refuse to accept speech drafts because they are irrelevant and privileged." Hinman's speech in 2018, in which he announced that Ethereum is not a security, became a major issue in Ripple's lawsuit against the SEC. In January 2021, Ripple demanded that the SEC provide documents leading to the wording of the speech, which contains 64 drafts of internal communications. However, the commission ignored Ripple's request, prompting the blockchain company to file a petition late last year to force the SEC to hand over the document. Judge Netburn ordered the Securities and Exchange Commission 3 times to hand over Hinman's documents to Ripple. The Securities and Exchange Commission is still not ready to hand over the drafts of Hinman's speech to Ripple. After the SEC's ongoing efforts to protect Hinman's drafts and other relevant documents that could help resolve the lawsuit, many believe the SEC is hiding something more. In one of his recent interviews, Ripple CEO Brad Garlinghouse asked a question that has long been of interest to everyone: what is the Securities and Exchange Commission trying to hide? 14 months, and they are still fighting to hide these records. What are they hiding? Asked Garlinghouse. The U.S. Securities and Exchange Commission has tightened its control over Coinbase after the platform increased the number of tokens it offers to trade, said 2 of the people who asked not to be named because the request was not made public. The investigation conducted by the SEC law enforcement agency preceded the agency's investigation of an alleged insider trading scheme, as a result of which the regulator last week sued a former Coinbase manager and 2 other people. We are confident that our rigorous due diligence process, a process that the SEC has already verified, prevents securities from entering our platform, and we look forward to engaging with the SEC on this matter, General Counsel Paul Greville said on Twitter. The SEC declined to comment. The drumbeat in Washington for U.S. regulators to do more to oversee cryptocurrency has grown louder as digital currencies have fallen from record highs, erasing hundreds of billions of dollars in market value. SEC Chairman Gary Gensler focused on trading platforms and said they should do more to protect retail investors. As the largest U.S. trading platform, Coinbase allows Americans to trade more than 150 tokens. If these products were considered securities, the firm might have to register as an exchange with the SEC. Coinbase shares fell $14 to $52.93 in New York, bringing the stock down 79% this year. Coinbase has repeatedly argued with the agency about how it oversees the industry, and last week the firm called on the SEC to propose clearer rules. Meanwhile, after several years of a relatively cautious approach, Coinbase has increased the number of its tokens. Tensions escalated further on July 21, when the SEC accused one of the company's former employees of violating insider trading rules by leaking information to help his brother and friend buy tokens just before they were listed on the platform. Although the agency did not claim wrongdoing by Coinbase, the SEC said it had established that 9 of the dozens of digital tokens the men traded were securities, including 7 that the exchange said were listed. Manhattan federal prosecutors have also charged the 3 men with conspiracy to use electronic communications and fraud using electronic communications. In response, Coinbase published an entry on its blog under the heading, "Coinbase does not place securities." The end of the story. Greville noted that the Justice Department chose not to press charges of securities fraud, despite having considered the same facts as the SEC. He also said that before listing tokens, Coinbase analyzes whether an asset can be considered a security, and also considers aspects of compliance with regulatory requirements and information security of the asset. Investigations conducted by the U.S. Securities and Exchange Division may lead to a regulatory body suing companies or individuals. Coinbase, which went public last year, previously admitted that it had been subject to regulatory scrutiny. In its first quarter earnings report, the firm said it received a subpoena from the SEC to obtain documents and information about certain client programs, operations, and prospective future products, including the company's stablecoin and revenue-generating products. To decide whether a digital asset is a security, the SEC applies a legal test based on a 1946 U.S. Supreme Court decision. In accordance with this structure, the agency believes that the token is usually within the competence of the SEC when investors invest money to finance a company with the intention of profiting from the efforts of the organization's management. Gensler has long argued that many cryptocurrencies fall under the jurisdiction of the regulator and that firms offering them must register with his agency. However, the SEC in most cases does not specify which coins are securities, and exchanges decide whether to list the asset. Platform operators tend to avoid offering these supposed securities because it could trigger investor protection rules, some of which, according to crypto enthusiasts, are incompatible with digital assets. What do you think are the prospects for XRP in 2023? Write your forecasts in the comments. Thank you for watching this video to the end. Please do not forget to like it and subscribe to the channel so as not to miss the release of new videos, and do not forget about our contest. Write in the XRP comments to add 500 XRP to your account.